Welcome, coffee drinkers. I'm Hallie Zobel. I'm an attorney at Private Corporate Counsel in downtown Orlando, Florida. Today we're going to talk about a statute that was enacted in 2018 to protect our vulnerable adults. What's a vulnerable adult? That could be someone with a disability. It could be an elderly person losing their faculties. It can be someone over age 18 that has Down syndrome or some other type of disability. The bottom line is, Florida has enacted a statute to protect these vulnerable adults. No other statute exists like this in the nation, to my knowledge. What this statute does is allows the vulnerable adult to go to court and visit the judge and get a temporary injunction with no notice to the bad party to stop any exploitation or neglect happening. So, for example, the people that can bring the injunction on behalf of the vulnerable adult is an agent under the durable power of attorney document, which you're familiar with, we've spoken about many times. It could be a guardian appointed by the court to handle the affairs of the vulnerable adult, or it could be someone who the vulnerable adult agrees to allow them to represent them. This temporary injunction does not require an attorney, and it's a quick and inexpensive method to provide relief for these adults. The temporary injunction can remove someone from a home, can stop the exploiter, can freeze a bank account, and can even freeze a joint account where an exploiter might have their name on it along with the vulnerable adult. Think of it as a domestic violence injunction statute. We've all are familiar with those injunctions where a husband or wife can go to the court and get a temporary injunction if they're being harmed by their spouse. The spouse is never notified, and this can, with the vulnerable adult, it can last up to 15 days. After the 15 days, there's a hearing where notice is given to the exploiter and evidence is taken by the court, and then the court makes a ruling. Perhaps the judge makes the injunction a permanent injunction to protect the vulnerable adult. Perhaps the judge releases monies back to the vulnerable adult after the assets have been frozen. Now, don't think their monies can't be reached by the vulnerable adult. The court can enter orders saying that certain bills are still paid on behalf of the vulnerable adult. So that's a good thing. It's been very well thought out. And advocates for the elderly and the disabled are applauding this document. Now, it's been about 6 years since the statute was passed, and where I see it being used is the following. A lot of times it's being filed along with a petition for incapacity and a petition for an emergency temporary guardian. When we go to the court to ask for emergency temporary guardian, we're asking the court for someone to step up and be guardian to protect another vulnerable person or incapacitated person. And here, this injunction would go hand in hand with those type of pleadings. I practice guardianship law here in Orlando in Central Florida, and I believe the clerk's office probably has a document for this temporary injunction if you should need it, to be completed by you and submitted to the court. Be sure to check out your local clerk's website to see this document, and I have a copy of it if you should need it. Of course, like anything else in the law, this proceeding can be misused and could be used for nefarious reasons to remove someone from a house improperly or paint someone in a bad light. And once again, though, this document and this proceeding is amazing to protect the vulnerable adults. A lot of my clients are in this category, and we have a duty, I feel, to protect these folks. And it is a fantastic statute, and there's various websites that you can read and get the document. One is turning18.org, or once again, you can contact my office at 407-647-7887 at Private Corporate Counsel. I'm Hallie Zobel, and I thank you for tuning in to Law Moment.